We are on the record, Judge.
Okay, thank you. In the matter of Turner versus Casales, case D 15-521-527C, please state your appearances. We'll start with counsel for plaintiff, Mr. Fleeman.
Good morning, Your Honor. Jack Fleeman, bar number 10584, on behalf of Mr. Turner, who is present via Blue Jeans as well.
Good morning, Your Honor. Gary Siegel, bar number 3220, Douglas Crawford Law, on behalf of Ingrid Rodriguez-Casales, who is also present on Blue Jeans.
Okay, very good. Thank you. Thank you so much for your patience. Let's see. So we got Dr. Berquist's report. Who wants to address the court first? Let me know.
Well, I do want the court to know that Mr. Fleeman filed a motion to modify custody temporarily. The court already has a full-day evidentiary hearing scheduled for June 3rd of this year. And we were notified of an order shortening time just this past Monday, putting his motion on for hearing today. And this was basically supposed to be a return hearing that we got Dr. Berquist's report. We also then have 2 months to go ahead and file a rebuttal report if we feel that's appropriate. And our evidentiary hearing is already scheduled. The court's already issued a scheduling order, and there should be no changes pending that time. That's the purpose of the evidentiary hearing, is to go ahead and hear the evidence and cross-examine the witnesses and put it all out there. So basically, this motion today is premature.
Thank you, Mr. Siegel. Mr. Fleeman.
Sure, Your Honor. I think the court needs to do something today because the child's at serious risk. The child has been at serious risk. The difference now is that mom knows what that report says, and the report confirms everything that dad has said. We have a real problem here. She's actively damaging my client's relationship with the child and the child's relationship with dad. The report puts it all out there. She's told the child to lie about sexual abuse. We had a Metro detective testify back in September at our first hearing who pretty much goes along with that and says mom can repeatedly filed false claims. She's exposing the child to horrible situations. She's videotaped the child performing adult acts on herself. And then she's asking in those videos, apparently, is this what dad does to you? She's obsessed with dad. She's gone to his neighborhood during his timeshare. She's taken the child to therapy without notice to dad or consent to dad. She then rails against him at the therapy sessions to the point where she has to be removed from the room. These are all things that we brought to the court's attention back in September, and the court put a couple of things in place and set the evidentiary hearing. We filed an emergency motion in November because it continued. She still was continuing to make claims of sexual abuse, kidnapping. There were problems at the exchanges. We had an emergency motion in front of Your Honor in January, and what happened at that time is the court said, look, there's a child custody evaluation. We'll wait till that's in. We're not going to do anything right now. And I showed at that time a video exchange where grandmother was trying to get the child into mom's car, and the child was going until mom grabbed the child and whispered something in the child's ear. The child began screaming and crying. I believe that what mom was saying was bad things about dad. We have the report now from the doctor who confirms all of that. She did it in front of the doctor. The child said, my mom told me to say this. Mom walked her out to the car after the doctor went to mom's house just so the child could say, my dad touches my pee-pee. And the doctor found that was completely staged, completely coached. This is a problem, and it's severely damaging to this child who's only 5 years old. And so, the court can sua sponte, even without my motion, modify custody under 125C0045 sub 2. Any order for joint custody may be modified on the court's own motion, even if it's shown the best interest of the child requires the modification. So we're asking for a finding that on a temporary basis, pending this evidentiary hearing, which is still 4 months away, we're asking for a finding that's in the best interest of the child to follow what the recommendation is, which is supervised visits to mom, not to be supervised by friends or family, and primary physical custody to dad. I understand there's an evidentiary hearing pending. These things have been going on. They've continued even with the court trying to put safety measures in place, and they're going to continue as we go forward. And the worst part is mom now knows that the report is there. And so we have a serious concern about the child at this point. There's also medical things where she overdoses the child on Miralax. All those things are in the report. We're pleading with the court to issue a temporary order. It's not a permanent thing. Mom will get her day in court, but we need to protect the child, Your Honor.
If I may,
Mr.
Judge.
Freeman. Mr. Siegel.
Yeah, if I may, Judge, Dr. Berquist's report, actually, she received a lot of information and a lot of communication from Mr. Fleeman. My client went ahead and agreed to Dr. Berquist at a time when she was not represented by counsel. She did not understand how these things occur and whether or not that she should have agreed to that by stipulation. And we stand ready to go ahead and produce a rebuttal report based upon the information and based upon witnesses and third parties that are actually going to support the allegations that Mom has been saying. Something's going on here. Mom has never had any type of a diagnosis of any mental infirmity, and Mom is adamant of being truthful with regards to the matters that have occurred in this case. Just because they didn't go ahead and, file a charges does not mean that it didn't happen. Therefore, we want the opportunity to go ahead and do a rebuttal report. We believe that Dr. Berquist's report is biased. And Dr. Berquist is not, trained or has the ability to go ahead and determine veracity of the parties. The issues of Mom overdosing are completely false, and she's going to end up having to bring the doctor in to go ahead and verify that, because the doctor has supported everything that Mom is doing with regards to the child's constipation. If anything, there's medical neglect by Dad because he is not following doctor's orders on those things. So we are requesting that everything remain same pending the June 3rd hearing before this court, so that the court has the opportunity to hear all the witnesses.
Your Honor, if I may real quick address that.
Mr. Fleeman.
Dr. Berquist noted that Mom does not have a diagnosis, and she also noted that Mom really wasn't filling out the testing paperwork or doing it correctly. She thought it might be a language issue. Mom speaks Spanish. Mom speaks English. The problem is that even when she was given simple Spanish words that she could clearly read, she was confused and acting like she didn't know what the words were. So they weren't able to get a diagnosis. Part of the recommendation is that she goes and she gets evaluated and that she receive whatever therapy she needs before she's not supervised anymore. As for witnesses, Mom provided witnesses to Dr. Berquist. Those witnesses were not good for her in the report. I showed a video at the last time where there was a woman who came up to my client's car and was saying, "You sexually abused your daughter. You're a bad person." That person is a witness in the recommendations and says, "I don't know anything. I've never met Dad. It's just what Mom told me." The doctors, same thing. It's what Mom told them. The therapist that Mom took the child to, they based everything on what Mom had told them, and then they were so concerned because Mom wouldn't stop railing against Dad in front of the child. Every single witness she produced all said, "We don't know anything about Dad having a problem. This is all what Mom has told us." It's the same thing with the Miralax. We have records, and my client has sole decision-making authority on medical right now. And one thing he did was he took the child to the doctor, and we've provided a report to the court previously. The doctor said, "Look, all this was based on what Mom told us. We've never observed anything. So we're going to stop it." And they told Mom directly because she walked into the office right after the thing. And the doctor said, "Look, you're not to give her any Miralax. Don't do anything. If you have a problem, come back here. It's after hours, go to the ER." So Mom waited a couple of days and then took the child to the ER, said she's constipated. We don't doubt that the child has some constipation problems and needs Miralax. That's not the issue. The issue is right before Dad gets the child, she gives her so much Miralax, and my client has sent her pictures even recently. Her underwear are completely soiled, liquid. Every single time he gets her, she has explosive, uncontrollable diarrhea for the first day, 2 days that he has her. So there's no doctor that's going to be able to come in here and say, "I prescribed it, Dad's not giving it." The doctor doesn't know how much Mom's giving her. Dad doesn't know how much Mom's giving her, except for the symptom of the child having explosive diarrhea every single time she comes. And then Mom's saying, "You need to give her Miralax." And Dad's saying, "I can't give her more Miralax. She's having explosive diarrhea this whole time." So there's no witness that's going to come in and support Mom. This is, we don't know who the rebuttal expert's going to be. Mom didn't have an attorney. I've been on this case for 2 or 3 years, back and forth. Mom's probably had 8 or 9 different attorneys. She fires them every time. when things start going south for her. This happened again recently. Mr. Crawford's office only recently came on. Mom had an attorney prior to that. I don't honestly recall whether the stipulation to Dr. Bergquist was in the middle of her attorneys. It was, and she certainly had an attorney since then and never objected to Dr. Bergquist, never said anything. It's only now that the report is there that they're saying, oh, she was duped. Dr. Bergquist is biased. There's no evidence of that. Again, there's far more smoke here than is necessary to even indicate that there's a fire. And it's unbelievable to think that the recommendations in the report are exactly in line with what Dad has been saying, and that Dr. Bergquist is lying in a report as to what she personally.
Mr. Fleeman?
Yes.
Oh, sorry, you froze for just a moment.
Okay. I'm sorry. I still may be frozen. I don't know. Am I?
No, you're good now. You're good now.
Oh,
just repeat what you just said.
Okay. What I was saying is I think it's unbelievable to think that Dr. Bergquist's recommendation in her report reports exactly what Dad has been saying, and that the witnesses are all in line with what Dad has been saying, and that it's all made up, that none of this happened. Dr. Bergquist is just biased and is against Mom somehow. There's more than enough smoke to indicate that there's a fire. This has been going on for years, and I have real concerns. My client has the child right now. When the child goes back to Mom, who knows what she's going to do? She's put the child in the middle in extreme ways. She's had multiple sexual abuse testing done on the child. She's taken her to therapists, and she's videotaped the child self-stimulating and asked the child on video whether or not this is what Dad did. I mean, it's just stuff that needs to stop, and there's no way to do it if she's not supervised.
Okay, Mr. Siegel, I'll let you respond.
Yeah, I mean, if you look at the ex parte application, the claim is that all of these things have been going on since last August, since the hearing on August 18th. Well, there's nothing new today except for Dr. Bergquist's report, and Dr. Bergquist's report has not yet had scrutiny by another expert to determine its veracity, as well as the methods that were used by Dr. Bergquist. We've got hearing already scheduled for 3.5 months from now, and the child, hasn't been shown to be any adverse effects on the child at this time, and we're just requesting the status quo pending evidentiary hearing, which is already set for June 3rd.
Mr. Siegel, Mr. Fleeman raises the issue that Mom should be evaluated herself. How do you respond to that?
Mom has never been evaluated in the past, is my understanding. I mean, I would think that counsel would have the right to go ahead and request a mental examination under Rule 35 if he felt that was appropriate.
I think that he's making that recommendation. Let me double check. Mr. Fleeman?
I haven't asked for a Rule 35 examination. The issue is that during the custody evaluation, that was part of it. She was evaluated. The problem was, and if the court looks at the report, the way Mom answered or didn't answer the questions didn't provide enough. So there's all these symptoms and problems that are going on. She needs to go, and I don't have the report right in front of me, but basically there's a recommendation in the report that she be evaluated. The recommendation, is supervised to Mom, primary to Dad, supervision not by a third party that's not a family member or a friend. There's a recommendation that my client receive counseling for past alcohol and drug use, which she's already doing. And then there was a recommendation that she get evaluated prior to having unsupervised, that she go and get evaluated. And I think there's some language in there specifically about what type of person might need to do that, since she wasn't really compliant with the testing when Dr. Bergquist tried to do it.
Okay, thank you, Mr. Fleeman. Mr. Siegel, I'll let you respond.
So in essence, what Jack's saying is that Dr. Bergquist didn't have a full picture also when she made her recommendations. So that's not a complete picture when she makes these recommendations at this point. And again, they haven't been scrutinized by another expert. And this matter is already set for hearing. There hasn't been shown to be any ill effects on the child at this point that can't wait another 3 months for the court to go ahead and have all the evidence before it and make its final decision.
Dr.
Okay,
Bergquist's recommendations. Dr. Bergquist's recommendation is not based on a finding of mental illness, although she wants that investigated. Her recommendation is based on what has happened, based on witnesses, based on mom, based on the child. You know, Dr. Bergquist witnessed mom walk the child out to her after the home visit, and the child walk up with no effect, no emotion, saying, "Daddy touched my pee-pee." She said that was clearly coached. Dr. Bergquist saw the video that mom took of the child self-stimulating herself and saying, "Is this what daddy does to you?" We had testimony from Detective Heredia back in September, who took the stand or testified basically in court, said, "Mom keeps coming here and saying sexual abuse. She keeps making the same claims. Even when we dismiss it, she comes back the next day and makes the same claims." We have the therapist that mom took the child to saying, "Mom rails against dad so much in front of the child that we had to remove her from the room." Dad wasn't even involved with that. Dad didn't even know that therapy was going on. The child is still being harmed. There's still the laxative issue too. The problem is, and mom admitted that dad had sent me pictures, and I didn't provide them to the court before because I told him, look, that's not really focused. But he has pictures of her in his neighborhood during his times in her car, like her car's in his neighborhood. She admitted in the report that she does go to his neighborhood and sit there when he has custody. There's serious problems here, and just because there's not a diagnosed mental illness, there's more than enough actual facts, most of them undisputed, that support a temporary modification pending an evidentiary hearing. And she can cross-examine Dr. Bergquist and have her rebuttal expert. That's all fine. It's only 4 months away. But I have really serious concerns about what happens if the child goes back to mom at the end of this week, based on what's happened and knowing that there's this recommendation out there now, Your Honor.
Okay. I want to take a look. I need to pause this video in order for me to pull up Dr. Bergquist's report, because I just want to take a look at her, the list of recommendations. So I need to take a brief recess, and I will be right back.
Sure, Your Honor. And I would also
that Dr. Bergquist's report has not yet been subject to scrutiny by the court or her testimony at the time of hearing herein, and basically, or a rebuttal expert.
I understand, right. Mr. Siegel, and your objections noted.
The only thing I was going to say is that Dr. Bergquist did a good job of bolding things throughout the report, I think, that yes. In addition to the findings.
I wish that I could access it while I'm speaking, and I can't. I have to pause this proceeding in order to take a look at it, and I'm worried that I might get cut out of Blue Jeans by doing that. But anyways.
And then, Judge, I've got an additional objection that Dr. Bergquist's report was not ordered by the court, and therefore for the court to even consider it at this point prior to it being introduced into evidence would be inappropriate.
I don't know what he means it wasn't ordered. It was stipulated to, and the court ordered it. And we have an order for Dr. Bergquist.
Yeah, what do you mean, Mr. Siegel?
It hasn't been subject to the testing its veracity with testimony at the time of an evidentiary hearing.
I understand all of that, Mr. Siegel, but you're saying it wasn't ordered by the court.
What I'm saying is that
what basis?
There was a stipulation in order appointing Dr. Bergquist to prepare a report. Yes, that I will agree. I understand. But what I'm saying to you is that to go ahead and admit that basically into testimony at this time is premature, without laying a foundation for the report and the court considering the report without a chance to be that the doctor's under cross-examination. So you're going to get a one-sided look at this time.
Okay. Your objection's noted, and so now we're going to recess, and I'll be right back. Just give me a moment.